Hot off the press, everybody. I have the mid-year revisions to the Georgia Association of Realtors contract package and want to go ahead and go over them with everybody. Hi, everybody. Dana Sparks, broker of Maximum on Greater Atlanta Realtors and director of the Real Estate Academy of America, here to bring you a series of videos on the mid-year changes that GAR, or Georgia Association of Realtors, is making to their contract package. Now, as expected, there are a lot of changes in reference or in response to the National Association of Realtors, or the NAR settlement. This is early June 2024. These revisions will be available to agents as of July 1st, 2024. Our school, the Real Estate Academy of America, will begin teaching these so that agents can get a handle on what these changes are, feel comfortable with them when going over everything with their clients and customers. And the classes we teach on this will either be called 2024 GAR contract dissection or 2024 GAR contract changes. So either one of those, our instructors will go over these changes. So again, I'm going to do a series on the mid-year revisions, and I'm just going to go over them one form at a time. I'm not going to cover all the revisions, but I'm going to cover the predominant ones that do impact agents here in Georgia, especially with respect to residential real estate. So let's dive in, shall we? And today's video is going to cover changes to the purchase and sale agreement. And I am just going to share my screen and dive in with everyone. So give me a second. All right. This is the revision. As you know, the Georgia Association of Realtors comes out with their new contracts, and thank you so much to the GAR Contract Forms Committee. They had a doozy of a time this year with some unexpected issues that they had to deal with, and they did a fabulous job. So thank you to all of Georgia Association of Realtors and the people on the GAR Forms Committee. So as you know, the new contracts come out at the beginning of the year, and then they do a mid-year revision, generally speaking, to correct typographical errors, syntax errors, spelling errors, things like that. And then there are usually a couple of doozies thrown in. Well, this year, again, this is June. I'm recording this video the beginning of June 2024. These contract revisions are coming out July 1st, 2024. There are some fairly major changes, again, in response to the NAR settlement, which has been ongoing in the news for several months. But as an agent, how you can know if it is a form that has been revised or not, at the very bottom, if it was revised, it will say 7/1/24. If you are utilizing a form where there were no revisions made, that date on the bottom corner will say 1/1/24. So for the purchase and sale, this is the revision of 7/1/24. Not a lot, but a couple of very interesting changes that you need to be aware of. So hang on, I don't mean to make you dizzy. The first change, generally speaking, throughout all of the contract forms, they have changed the term from commission to compensation. So you will see that change throughout all of the forms. In the section where it talks about the brokerage relationships, they've added compensation in this transaction to the title. And then as you scroll down, there is a brand new paragraph. We are on B10B, compensation of brokers. And basically this says, well, not basically, I'll read it to you. The compensation of the seller's broker and the buyer's broker, if any, for professional brokerage services shall be set forth herein or in a separate written agreement. If the compensation of any broker is set forth in this agreement, meaning in the purchase and sale agreement, or if the compensation is modifying a previously agreed upon compensation of the broker, the parties should attach a broker compensation agreement. It is a brand new form, F-259. I'll cover that in another video, to this agreement to reflect the same. If any provision in this agreement, including a provision in any amendment hereto, changes the total amount of compensation due to any broker from the total amount of compensation said broker had previously agreed to in writing, then such change to the broker's compensation is only binding if it is in writing. If the broker that is impacted by the change. So if the brokers have already agreed to compensation in another form, for example, instructions to closing attorney or compensation, it's going to take me a while to get used to that, to be agreed upon prior to showing. If that has been agreed upon and it gets changed in the purchase and sale agreement, the change in the purchase and sale agreement and the new exhibit F-259, I'll cover in another video, that only changes what was previously agreed to if it is agreed to and signed in writing. If so, then it is binding upon the broker impacted by such change if they agree to that in writing. If the broker in question does not agree to such change in compensation in writing, it is not binding upon them. So any changes have to be agreed upon by the brokers. If a licensee of a broker is signing this agreement on behalf of a broker, the licensee warrants that they have full authority to sign the agreement on behalf of and bind the broker. Remember, all licensees are affiliated with a broker. All contracts are done in the name of the broker. All compensation for transactions is done in the name of the broker. So it is a broker that can sign to change that compensation. If a licensee changes that compensation, then if the licensee is signing this agreement, they warrant that they have the authority of their broker to change it on behalf of their broker. All right, going back to reading. Whether the brokers involved in this transaction sign this agreement or not, they shall be deemed to express third-party beneficiaries of this agreement, shall have the right to enforce all provisions in this agreement that benefit or afford them rights and defenses, and shall have all remedies at law or in equity at the event of a breach of agreement. Buyer and seller agree that any compensation to be paid to the brokers shall be shown on the settlement statement and collected by the closing attorney as a precondition to the buyer and the seller closing on the property, as long as it is permitted by the buyer's mortgage lender if there is a mortgage lender. The closing attorney is hereby authorized and directed to pay the brokers at closing the compensation of the respective brokers pursuant to this agreement, or if compensation isn't addressed in this agreement, again, this is the purchase and sale agreement, then pursuant to a side agreement or written instructions from the brokers at closing. Then it goes on to say that if the sale proceeds are insufficient to pay the agreed upon compensation, the party owing the compensation shall pay any shortfall at closing. The acceptance by the broker of partial compensation does not relieve the party owing the same, the remainder of what's due after the closing, unless they've agreed to that in writing. Any broker acting as holder shall sign this agreement or a separate agreement consenting to the same. This agreement and any amendment hereto shall be enforceable as between the parties, even without the signature of any broker referenced herein. Again, they added that phrase because all commissions or compensation is earned in the name of the broker, but it is typically agents that sign the purchase and sale agreement. So that brand new paragraph, and there's similar verbiage, similar changes to compensation throughout many forms that we'll get to in other videos. This change is a major change. So you buyer's agents, pay attention. Under the default section, paragraph B2 default, the remedies of the buyer. So what has gotten changed is they have added an additional remedy for the buyer. So what does that mean? That means that if a seller defaults on the contract, in the event this agreement fails to close due to the default of the seller, the buyer may either, this has been the same, number one, seek specific performance of this agreement, meaning they go to court, they sue the buyer for specific performance, they bring that suit. A judge decides whether the seller has to perform and go through with the contract or not. That's what specific performance means. If a buyer pursues a specific performance suit against the seller, their earnest money stays in the deal and they wait until the hearing is heard by a judge. That's one remedy. That's been there. Number two, this has been there. The buyer may terminate this agreement upon notice to the seller and the holder, and in which case all earnest money deposit and other payments the buyer has paid towards the purchase of the property shall be returned to the buyer following procedures set forth elsewhere herein. That's been the other remedy. They can terminate, get their earnest money back, and go find another property. This is the mid-year change. And buyer may pursue any other remedy available at law. So that is humongous. That used to be in the contracts. They took them out and they have added that back in. Now the seller's remedies, if should the buyer default, is still earnest money. The earnest money as liquidated damages. So it's just the buyer remedy that has changed with this mid-year revision. Additionally, for any of you agents working with investors, there is a section they've added about investors. So the GAR purchase and sale agreements may not be assigned without the seller's written permission. That's been in there. What they have added is, well, I'll just read you this last paragraph. This agreement may only be assigned, and GAR gives us a hint, use special stipulation 611, that is with the seller giving the buyer permission to assign the contract. So this agreement may only be assigned or listed for sale in a multiple listing service by the buyer prior to closing with the written approval of the seller. And the seller does not have to agree. The written approval of the seller may be withheld for any or no reason. Any assignee shall fulfill all the terms and conditions of this agreement, including but not limited to the obligation to pay compensation owed by the assigner. So they've added information about listing it in an MLS service. And additionally, it goes on, the next mid-year change is a brand new paragraph about compensation. And it says, the term compensation as used in this agreement shall mean the compensation to be received by broker for performing real estate brokerage services in this transaction, regardless of whether it is a flat fee, percentage, bonus, or some other method of compensation. Brand new paragraph there. And the last change is under the exhibits and addenda. GAR did reference broker compensation agreement, which is a brand new exhibit that I will cover in another video. Those are the changes to the purchase and sale agreement. Comment below. I'm really interested to hear your thoughts on those. And stay tuned for new changes, more changes. The changes include, as expected, changes to the seller brokerage agreement, buyer brokerage agreement, buyer customer acknowledgement, that new form, the new amendment regarding compensation, and we'll cover the rest. So stay tuned to make sure you don't miss any of this series of videos. Please subscribe to my channel, click the subscribe button, and you will be subscribed every time I post a new video on the changes, and I am going to tackle this series. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors. satisfying your needs with service, innovation, and education. Bye. If you like that video, check out the one here. If you like the content on this entire channel, please click here to subscribe. I try to take even the most complicated of real estate situations and make them crystal clear. See what I did there? Real estate made crystal clear. Thank you guys so much for watching.